Imagine that all this time we've been pronouncing this word incorrectly. We've been saying bigamy instead of bigamy. It's actually bigamy. The mispronunciation is in these two particular videos: types of marriages in Zimbabwe and essential requirements for a valid marriage in Zimbabwe. Make sure to remember that it's bigamy instead of bigamy. As usual, another warm, fuzzy welcome back to Legally Dephine, and if you are new here, welcome. This is Legally Dephine, where we simplify the law. We are continuing with our lecture on formation of marriages in Zimbabwe, where in this video we are going to look at solemnization requirements for a civil marriage. Make sure to subscribe, share, and like. Let's get into it. As previously defined in our types of marriages video, solemnization is the formal legal process through which a marriage is officially celebrated and brought into existence before an authorized person. It is the ceremony that transforms an intention to marry into a legally recognized marriage. So before we start discussing the legal requirements, it is important that we understand what solemnization means. The Marriages Act provides different procedures depending on whether the marriage is a civil marriage or a customary law marriage. Not everyone can legally conduct marriages. Part 3 of the Marriages Act establishes the office of marriage officers. A marriage officer is a person who is authorized by law to solemnize marriages. In terms of Section 2 of the Act, marriage officer in relation to a customary law marriage means a magistrate, minister of religion, or a chief, and in relation to a civil marriage means a magistrate or minister of religion. A marriage conducted by a person who is not authorized as a marriage officer under the Act may create serious legal complications. Therefore, couples must always ensure that the person officiating their marriage is recognized as a marriage officer in terms of the Marriages Act. Civil marriages are primarily governed under Part 5 of the Marriages Act. These marriages are strictly monogamous, which means one husband, one wife, and no other spouse is allowed during the subsistence of that civil marriage. However, before a civil marriage can be solemnized, several procedural requirements must be met. Our starting point is Section 18, subsection 1 of the Marriages Act, which provides for the publication of bans or notice of intention to marry or issue of a marriage license before a marriage. It reads, subject to subsection 2, no marriage officer shall solemnize any marriage unless in respect thereof and in terms of this act or a prior law, each of the parties has caused bans of marriage to be published, or each of the parties has caused the notice of intention to marry to be published, or one of the parties has caused bans of marriage to be published, and the other has caused the notice of intention to marry to be published, or a marriage license has been issued. Now, let's discuss each of the requirements in Section 18, subsection 1 of the Marriages Act, starting with the notice of intention to marry. A notice of intention to marry is a formal notification given by the parties to the marriage officer or the registrar that they intend to marry. Its purpose is to start the legal marriage process and provide authorities with information about the proposed marriage. The notice of intention to marry usually contains details such as the names of the parties, ages of the parties, their marital status, and place of residence. Just think of it as formally informing the state that we want to get married or we intend to get married. Notice of intention to marry is in terms of Section 23 of the Marriages Act, which provides as follows. Any party who desires the publication of a notice of intention to marry shall apply in the manner prescribed to a magistrate to publish such notice. An application in terms of subsection 1 shall state the full names, age, status, and residential address of each of the parties, and bear the signature of each of the parties, and be dated by either of them. If the magistrate to whom such application is made is satisfied that the applicant has resided in the district in respect of which the magistrates hold office for a period of at least 14 days immediately preceding the date of the receipt of the application, he or she shall publish such notice by posting it in a conspicuous place or in the immediate vicinity of his or her office for a continuous period of 15 days. If only one of the parties concerned has so resided in such district, it shall, for the purposes of Section 18, be deemed that only such party caused such notice to be published. Every notice referred to in subsection 2 shall state the full names, status, and residential address of each of the parties desiring to marry. The publication of this notice serves as a safeguard against unlawful marriages. The law recognizes that the marriage officer may not know everything about the parties. Therefore, publication allows members of the public to raise objections if they know of any legal impediment. For example, someone may know that one of the parties is already in a civil marriage, or maybe one of the parties is underage, or they are within the prohibited degrees of marriage, or maybe the marriage is being entered into fraudulently. Here is a basic sequence of what we are saying. First, the parties give their notice of intention to marry. Second, the notice is published in the manner prescribed by the Act. Third, a waiting period follows during which objections may be lodged, in this case 15 days. And finally, if no valid objection is raised, the marriage may proceed. Remember, publication acts as a form of public scrutiny and helps prevent prohibited marriages from being solemnized. Publication of bans is the public announcement of an intended marriage by a registered minister of religion during a religious service for the purpose of informing the public and enabling objections to be raised where a legal impediment to the marriage exists. Publication of bans is a form of a public notice that allows anyone who knows of a legal reason why the marriage must not continue to come forward and object. For example, someone may know that one of the parties is underage, or they are closely related, or maybe one of the parties is already in a civil marriage. Application and publication of bans is in terms of Section 19 and 20 of the Marriages Act, and it reads: any party who desires to cause bans of marriage to be published shall deliver or cause to be delivered to any minister of religion at least 2 days prior to the intended publication, or at any such time prior to such publication as such minister of religion may in his or her discretion allow a written application to publish such bans, provided that no such application to publish such bans shall be accepted by a minister of religion unless the party concerned has resided in the area in which such minister of religion holds office for a period of at least 14 days immediately preceding the date of the receipt of such application. An application referred to in subsection 1 shall state the full names, age, status, and residential address of each of the parties, and bear the signature of each of the parties, and be dated by either of them. Nothing contained in this act shall be construed as compelling any minister of religion to accept and publish any bans of marriage. Any minister of religion or any person authorized by the authority governing the religious denomination or organization concerned may publish banns of marriage. Such banns of marriage shall specify the full names and residential address of each of the persons to be married, and publication thereof shall, subject to subsection 3, be made either in an audible manner sometime during public divine service on 3 Sundays preceding the solemnization of the marriage, in the face of the congregation before whom such minister of religion or other authorized persons officiates, or by posting the banns for an unbroken period covering 3 successive Sundays preceding the solemnization of the marriage in a conspicuous place or in the immediate vicinity of the ordinary place of worship of the congregation concerned. If the principal public divine service of a denomination or organization is held weekly on a day other than a Sunday, publication of banns in terms of subsection 2A may be made during such a service on such day instead of a Sunday. In very simple terms, the Act is saying that publication of banns is when a minister of religion announces in church that 2 people intend to get married. This announcement is made publicly so that if anyone knows of any legal reason why the 2 people should not get married, may come forward and object. This announcement is made for 3 consecutive Sundays. So the minister may say something like, I hereby publish the banns of marriage between Silas Mutadi and Mary Smith. If any person knows of any lawful impediment to this marriage, you may come forward. The ministers actually do say it like this, and if I manage to find some clips, I'll insert them in this video. The purpose is not to invite people to the wedding, but to make sure that if anyone has an objection to the marriage, they come forward and inform the minister of religion, who in this case will be acting as a marriage officer. For publication of banns, the sequence is: first, the parties inform the minister of religion that they intend to have banns of marriage published. Second, the banns are published in the manner prescribed by the Act, in this case for 3 consecutive Sundays. If no valid objection is raised, the marriage may proceed. As we have discussed so far, before a civil marriage can be solemnized, preliminary procedures like the notice of intention to marry and publication of banns are designed so that people who have objections may come forward and object to those marriages. It's also for accountability purposes and to ensure that unlawful marriages are not solemnized. However, there are situations where these 2 options may not be ideal. What then happens? The registrar issues what is known as a marriage license, which authorizes the marriage. A marriage license is in terms of Section 25 of the Marriages Act, and it provides as follows. Parties desiring to marry without the publication of banns or notice of intention to marry may personally apply to a magistrate for a license to marry without the publication of banns or notice to marry. The magistrate to whom an application in terms of subsection 1 is made shall require each of the parties to furnish him or her with their full names, age, status, and residential address, and may put to each of them such questions as he or she may deem necessary to determine whether any lawful impediment exists to the proposed marriage. If the magistrate to whom an application in terms of subsection 1 is made is not satisfied that the proposed marriage may be legally solemnized, he or she shall, in order to determine whether there is any lawful impediment to the marriage, interrogate each of the parties, demand the production of relevant documents, and institute such other inquiries as he or she may think necessary. For the purpose of any interrogation in terms of subsection 3, the magistrate may administer an oath to each such party. If the magistrate is satisfied whether or not after any interrogation and inquiries in terms of this section that there is no lawful impediment to the proposed marriage, he or she shall, upon completion by each of the parties of a solemn declaration to the effect that there is no lawful impediment to the proposed marriage, and upon payment of the prescribed fee, if any, issue to them a marriage license in the prescribed form. If the magistrate is not satisfied in terms of subsection 5, he or she shall refuse to issue a marriage license. So, if you don't get anything from this video, just remember that a marriage license is not a marriage certificate. I repeat again, a marriage license is not a marriage certificate. Just remember it as this. A marriage license gets you to the wedding. It gets you to be married. A marriage certificate is only given to you after you have been married and you have been registered. You receive a marriage certificate. Remember that. To further illustrate the point, here is a table showcasing the differences between a marriage license and a marriage certificate. A marriage license is issued before the marriage, and a marriage certificate is issued after the marriage. A marriage license gives permission to marry, while a marriage certificate proves that the marriage exists. A marriage license authorizes solemnization, whilst a marriage certificate serves as evidence of the marriage, and a marriage license is just a temporary document, whilst a marriage certificate is a permanent record of the marriage. Here's what we've discussed so far. The Marriages Act provides 3 alternative routes before a civil marriage may be solemnized. So it's either notice of intention to marry, publication of banns, or a marriage license. If you haven't understood it until this point, make sure to rewind. Objections to marriage are in terms of Section 28 of the Marriages Act, and it provides as follows. Any person desiring to raise any objection to any proposed marriage shall lodge such objection in writing with the person who makes publication of the relevant banns of marriage or notice of intention to marry, provided that, in the case of banns published in terms of Section 20, subsection 2a, any person desiring to raise any objection may do so orally, and such objector shall, if so required by the person making the publication, confirm such objection in writing, or the magistrate who issues a marriage license in respect of such proposed marriage, or the marriage officer who is to solemnize such marriage. If any such objection is brought to the notice of the marriage officer who is required to issue a certificate in terms of Section 21 or 24, or is to solemnize the marriage, or the magistrate who has issued a marriage license in terms of Section 25, such marriage officer or magistrate, as the case may be, shall inquire into the ground of objection and, if satisfied that there is no lawful impediment to the proposed marriage, such marriage officer may issue the relevant certificate or solemnize the marriage, as the case may be, and such magistrate need take no further action. If such marriage officer or magistrate is not satisfied in terms of subsection 2, he or she shall refuse to issue the relevant certificate or solemnize the marriage, as the case may be, and where a marriage license had been issued, such magistrate shall take steps to cancel the marriage license. The big take here is that any person may object to a marriage as long as they have a legal reason to do so, and they may direct their objections to the marriage officer, the minister of religion, or any person who is to solemnize the marriage according to the Act. What does a marriage officer do after an objection is raised? Number 1, the marriage officer must consider the objection. Secondly, the marriage officer may investigate the matter. Third, the marriage may be delayed pending investigation. And fourth, if the objection is found to be valid, the marriage cannot proceed. And finally, if the objection is found to be without merit, the marriage may proceed. So, publication of bans, notice of intention to marry, or a marriage license. What's the point for all this? The point is very simple and it's just one point: to make sure that we don't solemnize marriages which are illegal. And if you have watched until this very end, thank you. Make sure to subscribe, like, and share all our videos, and until we meet again.